Now call upon Jessica to come and give us her perspective. She'll introduce herself briefly to explain why is it important that we listen to her.
Thank you. Hi. First, please allow me to say how grateful I am for the opportunity to participate in this. Let me see if I can just make room for my giant computer here. How grateful I am to participate in this conference. It's such an important conference, and I'm so honoured to do so alongside such esteemed co-panellists. Thank you to the Permanent Bureau and the Steering Committee for organising this forum, and to Deputy Chief Justice Meyer and to our South African host for extending such a warm welcome. I hope you will forgive me for not preparing slides. I am not here to teach anyone about the convention. I'm just here to share my experience and my views on the topic of the convention and domestic violence, and I felt that slides would be surplus to my requirements in that regard. My name is Jessica Raffal. I am the Managing Lawyer of International Social Service Australia. International Social Service is a not-for-profit organisation that specialises in connecting families across international borders. We are part of a large international network and are mostly a social work organisation, but the legal service that I manage in Australia specialises in international parental child abduction and the 1980 Convention. We provide free advice to anyone who needs it in those areas, and our casework focuses on assisting parents to secure the return of their children under the Convention. So I imagine that there are those in the room, and maybe later in the program, who see the Convention primarily as a weapon wielded against women fleeing violence, and who may believe in this globally connected world in which international online hearings are entirely achievable, that perhaps it's outlived its usefulness. I don't intend to undermine those who share that view or speak against anyone's experience, but that is not my view. I don't personally share those views. My own experience as a lawyer specialising in this area is that in spite of the reality of the shifting profile of taking and seeking parents, the Convention does still serve its original intended purpose in many cases. Children are regularly returned, certainly through my work and that of my team, to protective custodial parents through the use of the Convention, where otherwise that would be far more difficult, if not impossible. I often see and speak with parents of children who have been removed to non-Hague or non-Hague compliant countries, and I can attest to just how challenging and heartbreaking those cases are. And I do not wish to see a return to the pre-convention days that some of you have witnessed and which Her Honour Justice Bennett referred. In short, I see value in the Convention, and I believe it is on balance a force for good. This reality does not negate the other reality, however, which is that in my view, the Convention does have a domestic violence problem. I also agree with Justice Bennett that the problem of domestic violence is not baked into the Convention, and it is essentially a domestic problem of contracting parties, but it is a domestic problem in all contracting parties. 1 in 3 women globally will experience intimate partner violence in their lifetime. We know that separated women are at higher risk of violence, and evidence suggests having a child also increases the risk of violence. These statistics are sobering, horrifying, in fact. And I'm sure you will have noted my use of gendered language. That is for the simple fact that this is a gendered problem. Whilst anyone can experience or perpetrate domestic violence and abuse, the fact is that women represent the overwhelming majority of victims and men the perpetrators. Women are also considerably more likely to experience repeated and severe forms of violence and abuse, including sexual violence, and they're also more likely to experience sustained physical, psychological, emotional abuse or violence which results in injury or death. The facts on this are simply beyond dispute, and if we are to go to all the trouble of arranging, attending, participating in such an encouraging, collaborative and optimistic forum as this, then I believe we should respect that process and respect the extraordinary amount of work done by the Permanent Bureau and the Steering Committee by being honest about the nature of the central problem. Obviously, victims of violence are going to be overrepresented amongst a cohort of women who have moved internationally with children without the father's consent. We should therefore expect on population-wide statistics alone that well over a third of Hague cases will have a domestic violence history, not just in allegation, but in fact. This is a universal problem that no country has solved. And yet, when these matters are determined, we see that allegations are sometimes treated with unwarranted scepticism. They are sometimes minimised, and even when they're found to be accurate and proven, the decision maker often defers to the ability of the other jurisdiction to protect the victim of violence. In the Australian state of New South Wales, where I practice, in 2023 there were around 40,000 domestic violence protection orders issued. In that same year, there were nearly 23,000 convictions for breach of a protection order, 55%. Anyone who has practiced or worked in this area will know the number of convictions is far lower than the number of breaches. New South Wales is not a lawless place, it's quite the opposite. So these numbers should be considered broadly representative of a global problem. The fact is that no jurisdiction has shown itself to be consistently capable of protecting victims of domestic violence. They are inherently vulnerable, due in large part to the private sphere in which that violence is so often committed. So when courts prioritise comity concerns over the safety of women and children, when they assume that the grave risk of violence can be solved by the use of protective measures, then the domestic violence problems of the contracting states become the Convention's domestic violence problem. One of the areas for improvement, in my mind, is for greater recognition of the fact that domestic violence perpetrated against the mother can constitute a grave risk to the child. There is abundant and compelling evidence, and we've heard from several speakers already, which have been presented over the past 40 years since the Convention's inception, which establishes as fact that exposure to family violence is highly damaging to children, and not merely for some small fraction of cases with the most extreme violence. Children exposed to family violence, even if they're not the primary victim, are at huge risk of poor mental and physical health outcomes. Depression, anxiety, complex PTSD, aggression, greater propensity to be subject to or perpetrate abuse later in life. Are these not grave risks? Even babies exposed to intimate partner violence in utero experience adverse outcomes like preterm birth, low birth weight, developmental delay, and long-term health effects like asthma and cardiovascular disease. Are these not grave risks? Are these not intolerable situations? When decision makers insist on an interpretation of grave risk, which recognises violence solely to a mother as a grave risk to her child only in the most exceptional of circumstances, they are denying this well-established reality. And I do not believe that this interpretation is mandated by the wording of the Convention. When the interpretation of grave risk ignores the research and becomes so unconnected from a natural human understanding of the phrase grave risk, then this has consequences not just for the parties to those proceedings and to the children who are the subject of them, but for those of us who view the Convention as a force for good overall. It also poses a risk of causing the Convention to become less relevant, less compelling. It heightens the risk of that reputational damage to which Dr. Bernasconi referred in his opening remarks. This risk may be diffuse, but it has real impacts for real families. India, for example, has not signed the Convention, and it cites amongst its reasons for not doing so concerns regarding protecting victims of violence. India is the world's largest country by population and has the world's largest diaspora. I see many, many clients whose children have been removed to India, and I can't help them, and I would love to be able to help them through the use of the Convention. I do not wish to suggest that these are easy problems to solve. They are not. Assessing allegations of violence is a challenge even in substantive family law proceedings. With that in mind, rather than proposing any solutions, I thought I might suggest some questions for consideration during the remainder of the program and afterwards. So how can courts properly assess allegations of domestic violence in what are limited or summary proceedings, often decided largely on affidavit evidence? How can the nature of the Convention as a forum selection treaty be reconciled with the reality for families that the ultimate parenting arrangement so often follows the Hague determination, often without subsequent litigation? It's often the case that the Hague decision is the only time that the allegations of violence will ever be heard and assessed. Is it right that that be done in such a limited way? Should Hague proceedings then be less constrained to permit greater fact-finding? In which case, how should the consequences for cost and time be dealt with? The new Australian International Child Abduction Respondent Scheme, to which Justice Bennett referred, is a scheme which pays the legal costs of respondents, and I think it's an excellent model. It addresses the key issue of inequality of arms, and it would ensure that Hague proceedings with greater fact-finding remain accessible to parents. I believe it should be considered for implementation by other state parties. We should also recognise that the longer duration of proceedings will invariably have consequences for the children who are the subject of those applications. So how should the possible downsides and risks be counted? If we're to make meaningful change in this area, then I believe these are just some of the practical matters which need to be considered. Thank you very much for your time and attention. I look forward to your questions and I look forward to listening.
Thank you very much, Jessica. Michelle.